taking the trust you had in me. You counted on me to help your children and with their tennis skills. And I stepped over my boundaries by filming for my own sexual desires. I cannot even begin to express how sorry I am for putting you through this. I know I can never change what I've done, but I can promise this will never happen again. Instead of seeking help, I told myself a lie. It wasn't hurting anyone because nobody knew. I now see the ripple effect that my poor decisions have had on these families, my former co-workers, and my own family. I accept full responsibility for my actions. I have a problem, and I've taken steps to get help. Since July, I have been seeing a professional counselor weekly who specializes with my issues. We have been working on figuring out how this all started and putting together an action plan on how to deal with my urges. I am truly, truly sorry for my actions and the pain that I've caused to everyone. I hope this sentence brings them healing.
These cases are always very difficult. I would imagine they're difficult for any judge to work with. Because it's difficult to know when you listen to all of the pain that you hear in these kinds of cases, how you translate a case like this into years. It's an inexact process, and it's difficult. Every defendant that comes into court is entitled to a sentence that's individualized for them, something specific to them. Sentences aren't supposed to be just simply a cookie-cutter approach where everyone gets the same sentence for a particular crime because everyone is an individual. In engaging in that process, I have a number of factors I have to consider, and I'm going to go through those factors. I need to consider the gravity of the offense, the character of the defendant, the need to protect the public, as well as other factors, including rehabilitative needs and punishment, and then craft a sentence in each case that's appropriate to that individual. When I consider the character of the defendant, there's a number of things that I need to consider. First of all, he doesn't have a prior record. That's something that the court typically considers in cases when considering someone's character. I consider all the letters that were sent in on his behalf. I've heard letters. I'm assuming some of the individuals are in court. I've heard from his parents. I've heard from his sister. I've heard from other relatives. Friends, and it's clear that they have seen many good character traits in Mr. Denault. The public needs to be protected from things like this. They really do. And it goes without saying that as we trust our children with people in these roles, teachers, coaches, daycare providers, other people in these roles, as we trust them and then get betrayed, we start to think, where's the next one coming from? Who's the next person that I can't trust? And the public needs to be protected from that inability to trust people around them. And this sentence has to reflect that as well. There are rehabilitative efforts that need to be undertaken, serious rehabilitative efforts. I can indicate I'm not going to sentence Mr. Denault to a sentence that's going to max out all the possible maximums and run them all consecutive. And there will be an occasion for you to be in the community again, but there needs to be extensive rehabilitative efforts undertaken before then, and then when that time does arrive, there needs to be supervision for an extended period of time because the community demands that of us. But those rehabilitative efforts have to be undertaken. There's a need for punishment, and it is certainly the case. I've heard it from people who have written to me, even though has been mentioned here today by Mr. Kippa, that even those who've written positive don't disown what happened, don't indicate that it wasn't serious, don't indicate that it wasn't tragic for our community. All of those things need to be taken into account because there is a need for punishment. The community demands that. It has to be made clear to all the victims that have written in and all the ones that have addressed me that these events were not their fault. I'm sure that their family and friends are going to be telling them that consistently. They may need some assistance with that in the future. I will say one of the unfortunate impacts of these kinds of events in our community is most human beings, as they grow up, want to develop close relationships with friends, family. They want to develop intimate relationships with other people. They want to develop sexual relationships with other people of their choosing. They want those types of relationships. It's difficult to understand how this type of experience is going to affect that long term. There really isn't any way to predict that right now. You'll probably only know the answer to that many, many years in the future, long after I have left this earth, when we ever know how this has impacted the young people that are in here today. Having said that, this case is about a sentence for Mr. Denault, and I have to balance all of those things. I've read the various submittals that have been given to me. I've listened to everyone, and I appreciate all of the input. As I indicated, this is not something that just comes to a judge, any judge, easily. These are difficult things. I'm satisfied when I consider all the factors that I'm required to consider. And I'm going to do the following. Neither of the parties have suggested a particular structure to their suggestions. I'm satisfied that what I'm going to do, first of all, I'm going to start with the Class D felonies. There are two of them. That would be count 2 and count 16. Those Class D felonies I'm going to structure as 7.5 years of initial confinement followed by 7.5 years. Strike that. 7.5 years of initial confinement followed by 10 years of extended supervision. Both of those. Those are going to run consecutive to each other. So each of the Class Ds will be 7.5 years followed by 10. The Class Cs are going to be concurrent to each other and concurrent to the Class Ds that I've now structured of 15 in and 15 out. 15 years of initial confinement followed by 15 years of extended supervision. Those will run concurrent. That'll be the sentence that the court is structuring on the Class Ds, consecutive. On the Class Cs, those will be concurrent, but they'll be concurrent also to the way I've structured the Class Ds. I'm satisfied that for the conditions of supervision, I'll require that there be no contact with any of the victims, no contact with anyone under the age of 18 unless prior approval given by the Department of Corrections, no contact with Four Seasons Tennis Club. I'm going to restrict the defendant. I'm going to order no coaching. There was a request that he not be allowed in any other exercise facility or training facility. Frankly, that's such a vague concept. The agent has some discretion in structuring this. I'm not going to address that. I'm going to address no coaching, no contact with Four Seasons, no contact with Western Racquet, participate in sex offender treatment, so an evaluation and follow through of recommendations. I'm going to order court costs. I'm going to order a compass evaluation and follow through. I'm going to comply with sex offender registry program. That'll be the order of the court. Questions, clarifications, Mr. Dorsey?
Judge, I would just ask, and this wasn't talked about during negotiations here, or I guess our finalized negotiations, but any restitution that might be submitted here after the fact for counseling related expenses, I would just ask for the 60-day total period.
I didn't hear any argument on restitution. What I'll do is this. I'll hold restitution open for a period of 60 days. I'm assuming, Mr. Dorsey, as we sit here right this moment, there isn't anything on it. Is that accurate?
Correct.
Okay. So 60 days, if I don't hear anything in 60 days, the number will default to 0. If there is a request, that'll be submitted to Mr. Kippa. He'll have 14 days to object. If there's an objection, there'll be a restitution hearing held. If there is no objection, then the new default number will be the number that's requested. Anything else, Mr. Dorsey?
No, Judge, thank you.
Mr. Kippa, questions, clarifications?
I'm sorry, it counts the Class D felonies. Can you just repeat the sentence on those? I'm not sure.
Sure. It was 7.5 years initial confinement on the Class D, followed by 10 years of extended supervision, consecutive.
Sorry, I thought those were the Class Cs.
Now we're going to make sure that everybody's on the
I'm sorry.
same page, because I don't want to have to come back and sort this out 6 months from now. So the lower level chart, first of all, nobody suggested how I should structure this, and everybody was looking for, but I'm not going to get into that. So I took the Class Ds. Class Ds indicating maximum initial confinement, 15 years, maximum extended supervision, 10. So I proposed 7.5 initial confinement, followed by 10 years of extended supervision for the Class Ds. They're going to be consecutive to each other. The other counts are Class Cs, where the maximum is 25 initial confinement, 15 extended supervision. And I ordered 15 and 15. Questions? Any concerns with the structure of the sentence?
No, I think it's appropriate, and I thank the court for breaking it down in that fashion. During our negotiations, that wasn't a topic that we discussed, and just didn't want to breach a plea agreement, so that's why the state gave a total recommendation.
And I just want to be clear, because I didn't finish my repeat off. So the repeat includes that those Class Ds are consecutive, the Class Cs are concurrent to each other, and concurrent to the Class D structure. Okay? Very good. If there's nothing else, then this matters.